Welcome to the 2023 Ohio Center for Law-Related Education High School Mock Trial State Championship. I'm Valencia Lang with the Supreme Court of Ohio. Since last fall, thousands of high school students have been preparing and competing against one another. The top two teams have advanced here today for the championship round. You're about to see their polished performance arguing a fictional court case live in a real courtroom setting before a panel of judges. What adds to the drama is that all season, each team prepares for both sides of the case, and they found out just minutes ago who will argue for the prosecution and who for the defense. This year's case is titled In Re S. Khan. The case examines the complexities of school investigations into incidents of misconduct, specifically when the misconduct may have criminal implications. These situations become even more complex when a school resource officer is involved. Students will examine the facts to determine whether a high school student was in police custody at the time they made incriminating statements, and if so, at what point the custodial interrogation began, and whether the student should have been advised of their rights. The mock trial should last about 2 hours before the judges take a break to score the teams. At that time, we'll be back for interviews with some of the students. Let's go now to the main floor of the courtroom.
First and foremost, congratulations to both of our mock trial finalists on your accomplishments so far. It is a great achievement to make it to the championship round. You should all be very proud of yourselves. I will keep this short and sweet so we can get to why you're all here, but I would like to take a moment to thank OCLRE's sponsors. So thank you to the Supreme Court of Ohio. We're in their beautiful building today. Thank you to the Office of the Ohio Attorney General. Thank you to the Ohio State Bar Association. Thank you to the American Civil Liberties Union of Ohio Foundation. And the Ohio Mock Trial Competition is made possible in part by a grant from the Ohio State Bar Foundation. So OCLRE is very grateful to the sponsors for making this program possible. Without further ado, I am going to turn this over to our esteemed judging panel to introduce themselves, and you can all get started. Good luck, everyone.
Start from the right side, if that's okay.
Is this on? Are we on? Morning. My name is Carol O'Brien. I'm Deputy Attorney General for Attorney General Dave Yost, and I am looking forward to this today. Good luck, everyone.
Good morning. I'm Caitlin Hill. I'm a judicial attorney for one of the justices of the Ohio Supreme Court. I did mock trial in high school and I loved it. So I'm really excited to be here judging you today.
Hello, my name is Patrick Dukes. I'm the Associate Vice President for Nationwide Mutual Insurance Company in their legal department. I've also been a mock trial attorney advisor for over 10 years, been a coach and a judge for many years as well, and I'm very happy to be here.
And we'll go to this end.
I'm Judge Dean Wilson from the Perry County Municipal Court. I've been judge for 33 years. This will be my last term as judge because of my age. And the Southeast Ohio District used to have this competition quite regularly, and they discontinued it, so I'm really looking forward to hearing the advocacy skills of both parties. Thank you for your participation.
Good morning. I'm Dave Hemanowski. I'm judge of the Probate Juvenile Court in Delaware County, and here in my capacity this year as president of the Ohio State Bar Foundation. And I think this is my 20th year judging mock trial competitions, but my first chance to do it at the state level. So good luck to all of you.
My name is, pardon me, my name is Steve Dauterman. I'm an attorney and regional fiduciary executive at Fifth Third Bank in Cincinnati, also serving a term as president of the Ohio Center for Law-Related Education. Very proud to be here. I've been judging mock trial for over a decade and enjoy being here at state, whether I'm on this panel or whether I'm in the audience. It's always wonderful to see this level of competition. So good luck to all of you.
My name's Jerry McBride. I'm a retired judge now. I was a judge for 31 years in Claremont County. First as a county court, then municipal court, and 27 years as a common pleas judge. I've been involved in mock trials since, I believe, 1994, when an attorney whose team happened to win the state championship 2 times, but was a friend, and he came in the court and said, "You really ought to get involved in mock trial. It's a great program. I think if you did it, you would really enjoy it, and you can't, it's impossible to believe how good the students do in their preparation and their performance. And so I got involved, and so I've been on the competition committee for a number of years, district and regional coordinator for a number of years, and think it's a great program. So everybody's introduced themselves. Okay. Has the bailiff of open court? If you go ahead and do that.
All rise. Hear ye, hear ye. U.S. District Court of Middle District of Ohio, Columbus, Ohio, is open to pursuant into adjournment. All business before this honorable court draw near, give attention, and you shall be heard. You may be seated.
Before we begin trial, I have a brief message to share with today's participants. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. As participants in the Ohio Mock Trial Program, it is important to resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting bias, prejudice, or public opinion influence your behavior inside or outside of the courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. And that is a statement that has been read this year before every competition that has occurred. If the bailiff then would swear all the witnesses in.
Will all witnesses and parties swear to give a testimony in these proceedings, please step to the front. Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and your testimony will comply with the rules of Ohio mock trial competition? I do.
In terms of, I think we discussed this in the pretrial, but in terms of introduction of teams, before you make your opening statement, you can go ahead and introduce your team members. That will not count as part of the time for the opening statement. Then you can make your opening statement. And so prosecution can proceed first.
Yes, Your Honor, and good morning. My name is Thomas Lopez. I'll be representing the state in today's case, along with my co-counsel.
Good morning, Your Honors. My name is Gavin Addington. I will also be representing the state, and today we'll be calling 2 witnesses.
Good morning, Your Honor. My name is Matt Doherty, and today I will be portraying Remi Silva.
Good morning, Your Honors. My name is William Plavin Masters, and I will be portraying Ari Nowak, and our timekeeper.
Good morning, Your Honor. My name is Kate Driscoll. I'll be timekeeping.
Thank you.
May I proceed, Your Honor?
You may.
May it please the court. Your Honors, we're here today because of a conversation. On the morning of September 9th, 2022, a prank was pulled at Trillium High School. The prank being that someone had put exploding lemon candy into the eggs at the Trillium High School annual alumni breakfast. The alumni breakfast is the biggest fundraiser for Trillium High School, bringing in over 60% of the athletic budget for the year. But this was no harmless prank. Once patrons realized that the eggs were tainted, they left almost immediately and did not stay for the silent auction, causing Trillium to lose out on thousands. Dean Remi Silva was tasked with finding the prankster, and through conversations with both students and staff, found the defendant, Junior Stevie Khan, responsible. The defense has filed a motion to suppress statements made by the defendant while having conversations with both Dean Remi Silva and School Resource Officer Ari Nowak. My co-counsel Gavin Addington and I, however, will prove that the school did not violate the defendant's Fifth Amendment rights by not reading him his Miranda rights prior to their conversation. The Court of Ohio has ruled on an issue of this nature in the past, in the case of In re Haubiel. In this case, a student appealed the judgment on the grounds that they did not knowingly, voluntarily, and willingly waive their Miranda rights. The court ruled that the school environment was non-coercive in nature and that no sufficient evidence could be laid to show that the student was not free to leave at any point during their conversation. Now today you will hear from two witnesses. First, we will call Dean Remi Silva to the stand. He will testify on his investigation into this school disciplinary matter. He will testify that he informed the defendant he broke school policy when he pulled this prank, but most of all, you will hear that this was a school disciplinary matter being addressed with school disciplinary action. We will also call School Resource Officer Ari Nowak to the stand. He will testify on why he was involved in this school disciplinary matter. You will hear that he did not limit the defendant of his freedoms by closing the door to the SRO office. Rather, he protected the confidential nature of their conversation. He will also testify why Miranda rights would simply not be applicable to their conversation. Now, the defense will argue that this would constitute a custodial interrogation. Now, the landmark Supreme Court case of Miranda v. Arizona gives us factors to determine whether a custodial interrogation has occurred. A custodial interrogation is one in which a person is 1, in custody, and 2, being interrogated. Questioning must also be initiated by law enforcement. Now, applying this to our case today, we will see that 1, the defendant willingly walked with Dean Silva to his office. 2, he continued to converse with Dean Silva and SRO Nowak, and that it was Dean Silva who had initiated their conversation. The Fifth Amendment as well states that no person shall be forced nor coerced to bear witness against themselves in a criminal investigation. And as your honors will hear today, the defendant was not forced nor coerced to bear witness against himself, and certainly not in a criminal investigation. The state bears the burden of proof in today's proceedings, and throughout testimony and evidence heard today, it will be made abundantly clear that the exchange between Dean Silva, SRO Nowak, and Stevie Khan was nothing more than just a conversation. The state respectfully requests that at the end of today's proceedings, you rule in favor of the state, that all statements made by the defendant be made admissible. Thank you.
Defense counsel, you may introduce your team members and then make your opening statement.
Yes, Your Honor. My name is Shershawn Moore. I'll be doing the opening for today. I will be directing Adrian Sato, portrayed by Kate Bolenbaugh.
Good morning, Your Honors.
Good morning, Your Honors. My name is Muhammad Khan. I will be doing the closing statement for the defense today. I will be direct examining Stevie Khan, portrayed by William Salzarulo.
Good morning, Your Honors.
And our timekeeper today is Elliot Burbrick.
Good morning, Your Honor.
Your Honors, opposing counsel, may it please the court. Schools have two major responsibilities: to educate their students and to keep them safe. In order to fulfill the second, many school districts, including Cardinal County, work with law enforcement to employ police officers on their campuses. These school resource officers, or SROs for short, sometimes work with school officials to question students. Sometimes this questioning becomes a custodial interrogation. And when a student becomes a suspect and a schoolhouse becomes a station house, that student is entitled to the safeguards of the Fifth Amendment. Your Honors, it's 1:30 p.m. on Thursday, September 15th, 2022 at Trillium High School. Junior Stevie Khan is sitting in class when the Dean of Students, Remi Silva, pulls him out and takes him to their office. The conversation begins about an issue of cheating, but quickly shifts to the topic of a prank that occurred at the alumni breakfast the week prior. 15 minutes into questioning, Stevie asks the dean if they can leave, but the dean ignores their request and instead confronts Stevie with evidence against him. Thus begins over 2 hours of a custodial interrogation headed by 2 agents of the state for Miranda purposes, Dean Silva and SRO Ari Nowak. The term custodial interrogation, however, requires some elaboration. The courts in Miranda clarified that a custodial interrogation means questioning initiated by the state after an individual has been placed into custody or otherwise deprived of their freedom of action. Today, your honors must use the objective facts in the totality of the circumstances using the reasonable person standard. You have to ask yourself, would a reasonable 16-year-old kid have felt free to leave? The prosecution bears the burden in today's case and must prove by a preponderance of the evidence, meaning more likely than not, that a custodial interrogation did not occur. They will not be able to meet that burden, your honors, because you will find that the totality of the circumstances cuts towards custody. The prosecution will call 2 witnesses today. Dean Remi Silva will testify that before and during the alumni breakfast prank, they worked closely with Officer Nowak on how to deal with pranks. Officer Nowak will testify that they were in their police officer uniform with a badge, handcuffs, and a firearm when they took 16-year-old Stevie Khan into their office, shut the door, and told them and threatened them with criminal charges. Your honors, when a student becomes a suspect, and well, first I'd like to introduce my witnesses, but we will call 2 witnesses. First we'll call the defendant themselves, 16-year-old Stevie Khan. Stevie will testify that during the over 2 hours that they were in custody, they attempted to leave 4 times. And each and every one of those times, they were either ignored or flat out denied. Next, we'll call licensed clinical counselor Adrian Sato. Ms. Sato will testify that the adult brain is different from the adolescent brain, and that an average adolescent in Stevie Khan's position on September 15th would not have felt free to leave. Your honors, when a student becomes a suspect and a schoolhouse becomes a station house, those who have that student in custody must Mirandize. As the objective fact finders in this case, we are confident that you'll find that the totality of the circumstances cuts towards custody and that there were 2 agents of the state for Miranda purposes. It is for these reasons that my co-counsel, Muhammad Khan, will come before you at the conclusion of today's trial and ask that you find in favor of the defense and grant our motion to suppress. Thank you.
Thanks to both counsel. The prosecution may call your first witness.
Yes, Your Honor. We call Remi Silva to the stand. May I proceed, Your Honor?
You may.
Good morning. Can you please state your full name for the court?
Of course. My name is Remi Silva.
What is your current occupation?
I'm the Dean of Students at Trillium High School.
How long have you been working as a dean?
Approximately 10 years now.
Do you have any prior work experience?
Yes. I was in the police academy for a short time. Unfortunately, due to a major injury, I was forced to drop out of the academy. I went back to college and got my master's degree in education administration.
So to be clear, are you a law enforcement officer?
No, I am not.
Now, moving back to your role as dean, what are your job duties?
I work in various different roles, including student supervision, guidance, leadership, and discipline. In summary, my job is to make a safe, welcoming, and well-run environment at Trillium High School.
How have you done this at Trillium?
I investigate and discipline student violations of school policy.
Do you have any recent examples of school policy violations?
Yes. We've recently seen a rise in pranks. The most common of these pranks is the TikTok trend known as the exploding candy challenge, where you place exploding candy into someone else's food and film it.
Has this prank affected the school in any way?
Usually they're minor disruptions to our school day. However, this was not the case during our alumni breakfast.
What happened during the alumni breakfast?
It started out as normal. We were going to serve some food and then hold a silent auction. The proceeds of that auction go towards 60% of our athletic department's budget. However, before we could actually serve the food, as soon as people started biting into the eggs, they discovered that exploding candy had been placed into this food.
What, if any, precautions has the school taken to prevent these pranks?
We've all started to receive training on how to deal and discipline pranks, as well as we held a meeting back in April about this very topic.
Would you recognize an agenda from that meeting if shown to you today?
I would, yes.
Your Honor, at this time, let the record reflect that I'm showing opposing counsel a clean and unmarked copy of what has previously been marked Exhibit A. May I approach the witness?
You may.
Thank you.
Dean Silva, what is this document?
This is the agenda for our meeting we had back in April.
And is this a fair and accurate depiction of that document?
Yes, it is.
What does this document discuss?
We discussed multiple things, but the main focus of the meeting was about TikTok challenges and pranks and how to discipline them. We spent nearly an hour from 3:55 to 4:50 just discussing pranks.
Could you please read the section labeled 4:10 p.m. for the court?
Year-end pranks, anticipated pranks, discipline for pranks, SRO involvement in investigation of pranks, administration involvement in investigation of pranks, and when to involve law enforcement.
So with that in mind, who handles the discipline for these pranks?
As you can see from this document, we discussed how both the SROs and administrators are involved in disciplining some pranks.
Now, moving back to the breakfast, what did you do immediately following the breakfast?
I had a meeting with SRO Nowak. He's one of our school resource officers, and I informed him what had happened and what we should do going forward.
What was your plan moving forward?
To treat this as a school disciplinary matter. A student had violated our rules, and this needed to be punished. He needed to be disciplined for it.
What did you do immediately following this meeting?
I went through the cafeteria. I wanted to see if I could learn anything as to how our breakfast was disrupted.
What did you learn?
The door connecting the cafeteria and the gymnasium had been left unlocked the night before the breakfast.
Is this significant in any way?
Yes. This is the only entrance into the cafeteria through the school.
So what did you do with this information?
The next week, I held a meeting with SRO Nowak, Mr. Rowan Tesfaye, the head administrative assistant at Trillium, and Mr. Blair Georgiou, the head of our honor board.
You mentioned the honor board. Could you explain that to the court?
Yes. It's our disciplinary council that's led by students. It deals with minor infractions such as cheating or skipping class.
Now, what was discussed in that meeting with SRO Nowak, Mr. Tesfaye, and Mr. Georgiou?
Two things. Firstly, this was not a criminal matter. Secondly, I suggested to Mr. Georgiou that all students facing the honor board and any disciplinary action from that honor board should be asked questions about if they were involved with the alumni breakfast.
What was the result of that decision?
It came to my knowledge that Mr. Stevie Khan could potentially be involved with the alumni breakfast incident.
So what did you do first?
That afternoon, I went to Mr. Khan's classroom and asked if he would come with me in my office for a conversation. When we arrived, I kept the door open and asked Mr. Khan to take a seat across from my desk.
How did your conversation with Mr. Khan begin?
At first, I asked him about his cheating on a test. It's why he was in front of the honor board in the first place. I then moved on to asking a couple questions about the alumni breakfast incident.
And how did Mr. Khan respond?
Mr. Khan asked to leave to go back to class.
What was your response to that request?
I made it known to Mr. Khan that if he stayed, we could resolve this issue faster. However, I never forced Mr. Khan to stay in my office or even indicated to him that he must stay in my office.
Did Mr. Khan choose to stay in your office?
He did, yes.
How did your conversation continue from there?
We then continued and asked we continue along with the conversation about the alumni breakfast. Mr. Khan then asked why he was in my office in the first place. I responded it was because of information Mr. Georgiou had given me.
Did you ever bring Mr. Georgiou into your office?
I did, yes.
What happened when Mr. Georgiou joined the conversation?
We discussed the information Mr. Georgiou had given me and why we believe Mr. Khan was in my office. I then left to talk to the kitchen staff because they could potentially know how the exploding candy got into the eggs of the breakfast.
And what did you learn from that?
The kitchen staff had no knowledge of how the exploding candy got into the eggs at the breakfast and did not pull this prank.
Did you ever return to your office?
I did after about 20 minutes.
And what happened when you returned?
Mr. Khan got very loud. He said, "What are you going to do, expel me over some exploding candy?" After he said this, SRO Nowak entered the room.
What happened when SRO Nowak joined the conversation?
Mr. Georgiou left for basketball practice. Mr. Khan asked to talk to his coach about missing practice.
What was your response to that request?
I said that I could talk to his coach after our conversation was through. However, I ultimately left the choice up to Mr. Khan if he wanted to go or wanted to stay in my office.
Did you ever ask any more questions of Khan?
I asked only one more question. I asked Mr. Khan about the unlocked door. However, before Mr. Khan could reply, I was interrupted by an important phone call. By the time I was finished, Mr. Khan had left the building.
Now, Dean Silva, was this questioning out of your ordinary duties as dean?
No, it was not. As dean, which I've been for 10 years, my job is to discipline students for violating school policy. Mr. Khan potentially violated our school rules and this needed disciplinary action.
Thank you. No further questions at this time.
Any cross-examination?
Yes, Your Honor. Good morning, Mr. Silva. My name is Shirshang Moore. I'll be asking you a few questions on behalf of the defense.
Okay.
So as you stated on direct, you've had meetings in the past on how to deal with pranks, correct?
We have, yes.
And you still have with you a copy of that agenda?
I do, yes.
Let the record reflect that I'm showing opposing counsel a clean and unmarked copy of what has previously been entered into evidence as Exhibit A.
Record will so reflect.
Now, Mr. Silva, as you testified on direct, you presented on TikToks here, right?
We did, yes.
And SRO Novak presented on pranks.
Yes, that was his section.
They presented on SRO involvement on pranks, correct?
He did, yes.
They also presented on the separate involvement of school administration, right?
Yes, he did.
So you'd agree with me when I say that SROs and school administration have separate roles when dealing with school pranks, right?
Well, in fact, we actually talked about how SROs can be involved with school disciplinary action when needed. That was part of what we discussed at the meeting.
But primary responsibilities are separate.
Again, if SRO Novak needs to enter the conversation, he will.
So SROs and school administration can work together?
Yes, they can.
Now I'd like to talk about the day of the breakfast, September 9th. So you say that this was a disciplinary issue, right?
This was, yes.
And the first thing that you did was speak with SRO Novak, correct?
Again, I wanted to make sure that this wasn't a criminal matter and that this was only a school disciplinary matter.
And that was also to determine the next steps in your investigation, correct?
It was, yes.
And that very same day, you were on the phone with the Harmony Police Department, right?
That's also when I learned that the Harmony Police Department were not treating this as a criminal matter. In fact, they were sending no one to the building at all.
Well, at that time, they actually gave you tips on what to look for, correct?
They did, but said that it wasn't a criminal matter and that I should be on my own for the investigation.
Is that a yes to my question?
Yes, it is.
And they also encouraged that you work with SRO Novak on this project, right?
Yes, since this is a school disciplinary matter, we're going to treat it with a school disciplinary investigation.
Now, it's true that you have had police training in the past, correct?
For a short time, yes.
And in terms of your investigation of September 9th, on that day, you never questioned any of the breakfast attendees, correct?
Yeah, everyone had already left by that point, and I didn't believe that I could ask them any questions because they were already outside the building.
And you never questioned any school staff?
No, not at that time, no.
You never questioned any students?
Actually, I asked multiple students about what had happened on that day, but they all did not know anything.
Well, the first time that you began any formal questioning was almost a full week later, 6 days later, on September 15th, right?
Once I actually had some information to work off of, yes.
Now I'd like to talk about September 12th. On that day, you had a meeting with Rowan Tesfaye, Blair Georgiou, and Officer Novak, correct?
Yes, that's correct.
And at that meeting, you recommended to the group that questions about the alumni breakfast be brought up at the upcoming honor board meeting, right?
Yes, any student who could be facing one disciplinary action could potentially be facing another.
And everyone agreed to this, correct?
Yes.
That includes Officer Novak?
Yes, he did.
Now, I'd like to talk about September 15th after the honor board meeting had concluded. So, that morning, Blair Georgiou came into your office, correct?
Yes, he did.
And they informed you of their suspicions of Stevie?
Yes.
But Stevie wasn't the only person who heard of your suspicions, were they?
I'm not sure I understand the question.
Well, SRO Novak was in your office at the same time, correct?
Well, actually, SRO Novak's office is just across the hallway from mine. He was just in the administration suite and happened to overhear our conversation.
So it's your testimony today that Officer Novak was not in your office when Stevie came to you?
It's my testimony. Firstly, Stevie never came to me.
Oh, excuse me, Blair.
Secondly, SRO Novak was in my office because he was in the administration suite and happened to overhear our conversation.
So they were in your private dean's office, correct?
Yes, they were.
Okay.
The door was open at all times, and most people can hear anything that happens in the administration suite.
Now, that very same day, you called Stevie down to your office, correct?
Yes. That afternoon, I asked Mr. Khan to come to my office for a conversation.
And you took them to your office yourself, right?
Yes, I did.
And once you began asking questions about the alumni breakfast, they did ask to leave, correct?
Yes, Mr. Khan asked to leave my office.
And you never told them yes, did you?
In fact, I left the choice up to Mr. Khan if he wanted to stay or wanted to go.
You never explicitly informed them that they were free to go?
There was no need to. I made it clear to Mr. Khan that he could stay if he wanted to or could leave if he wanted to.
Well, it's true that students in your school need a hall pass for freedom of movement, correct?
Yes, it is.
And a student in your office for disciplinary reasons needs permission to just up and go, right?
Yes. Of course, if Mr. Khan had asked for a call pass and wanted to leave my office, I would have been happy to write him one.
And to be clear, Stevie did ask for you to leave, right?
And when I left the choice up to Mr. Khan, he chose to stay in my office.
Now, eventually called in Blair Georgiou, correct?
Yes, I did.
And they laid out their evidence against Stevie Khan, right?
Yes, they did.
And then you got up to leave.
Yes, I wanted to talk to the kitchen staff.
And again, you saw Stevie Khan stand up to go, correct?
No, Stevie Khan attempted to follow me to the cafeteria. I felt it improper that Mr. Khan follow me there.
They did attempt to leave your office, though, correct?
They attempted to follow me to the kitchen staff area, to which I responded that I did not want them following me to the kitchen staff area.
So at this point, Stevie Khan, despite standing up to leave, did not leave, correct?
Stevie Khan chose not to follow me to the cafeteria.
So they did not leave.
Mr. Khan chose to stay.
Now, eventually you came back, correct?
After about 20 minutes with the kitchen staff.
And the SRO joined you in your office, correct?
Yes.
And at no point did you ask the SRO to leave your office, did you?
No, this was a school disciplinary matter, and 2 disciplinarians were handling it.
Eventually you got your important phone call, right?
I did.
And at this point, Stevie and the SRO left your office, correct?
Yes, they did.
But that wasn't the last you saw of Officer Novak, was it?
No, it was not.
You actually had a meeting with him at around 4:30 p.m.
I walked into SRO Novak's office. It was not a meeting.
Well, they informed you of what happened with Stevie Khan while they were alone, correct?
Yes.
And that seemed pretty incriminating to you, didn't it?
Well, in fact, everything Stevie had said to me seemed very incriminating, especially the part where he said, "What are you going to do, expel me over some exploding candy?"
So, statements that Stevie made to you and the SRO seemed incriminating?
Yes, I believed Mr. Khan to be the perpetrator of this prank.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. Mr. Silva, are you a law enforcement officer?
No, I am not.
What is your role in Trillium?
To be a disciplinarian first and foremost.
What did the Harmony Police Department tell you when you got off the phone with them?
This was not a criminal matter and should not be treated as one.
Now, why did you initially call Stevie down to your office?
I wanted to ask about his cheating on a test. It's a disciplinary matter as well.
And what was your response to Mr. Khan's request to leave every time he asked?
I left the choice to Mr. Khan if he left or stayed in my office.
Thank you, Your Honor. No further questions at this time.
Any recross?
Yes, Your Honor. Mr. Silva, when you were conversing with the Harmony Police Department, they did give you tips on what to look for, correct?
Yes, they did.
And to be clear, they encouraged you to work with SRO Novak?
Yes, they did. This was a disciplinary matter,
Throughout
so
this
we should work
entire
with disciplinarians.
interaction, you did work with SRO Novak, correct?
Yes, I worked with another school disciplinarian.
You worked with them closely?
Yes.
Thank you. No further questions.
You can step down.
Thank you, Your Honor.
Does the prosecution have any additional evidence?
Yes, Your Honor. At this time, the state calls Ari Nowak to the stand. Good morning. Could you please introduce yourself to the court?
Hi, I'm Ari Nowak.
And what is your current occupation?
Well, after about 10 years working on the Harmony Police Force as a detective and an officer of the law, I took up the school resource officer position at Trillium High School.
Did you receive any education or training for your role within the Harmony Police Department?
I did. I received my undergrad in criminal justice and then graduated from the police academy in order to become an officer.
Now, you stated that you took the role as school resource officer. Why was that?
Well, the role as school resource officer allows you to act as a mentor towards the children at the high schools you work at, something that an ordinary officer can't always do.
And did you receive any additional education or training for your role as school resource officer?
I did. I received training in how to interact with children and students rather than with a criminal element, particularly on when something is just a conversation with a student versus an actual interrogation.
Now, Mr. Nowak, do you know why we are here today?
I do.
And why is that?
Because Mr. Khan believes that he needed his Miranda rights read during the conversations he had with Dean Silva and myself.
And what got Dean Silva and yourself involved with Mr. Khan?
Well, Dean Silva and I have a responsibility to take care of student disciplinary issues at the school and to protect both the faculty and students at Trillium High School.
So, to your knowledge, why was Mr. Khan brought down to Dean Silva's office on September 15th?
To my knowledge, Mr. Khan had cheated on a test, and in addition to questions about that, Dean Silva wanted to inquire about the breakfast since he was in attendance.
And what got you involved in that conversation?
Well, at the time, I was going back and forth between my office and the copier when I overheard a rather loud conversation about evidence in the prank, so I figured that my insight, since I've dealt with pranks in the past, could possibly be useful.
So what role, if any, did you play in their conversation?
Well, I simply provided some important context on repercussions that have happened in the past, some criminal, to events such as this.
Now, Mr. Nowak, as someone who has experience both in law enforcement and as being a detective, are you familiar with Miranda rights?
I am.
And what are Miranda rights?
Well, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, and if you cannot afford one, one will be provided for you.
And from your experience working in the law enforcement field, when have you been required to read Miranda rights to citizens?
In my experience, Miranda rights have only ever needed to be read when someone is detained by law enforcement, taken down to the station, and then questioned by one or more officers.
Is Dean Silva a police officer?
He's not, no.
Could he conduct a formal police investigation even if he wanted to?
He could not. Everything that Dean Silva does is in his capacity as a school disciplinarian and as a dean.
So after the conversation between Mr. Khan and Dean Silva in Dean Silva's office, what happened next?
Well, after their conversation, Dean Silva had to take a rather important phone call, something more important than a prank, I presume, and I invited Mr. Khan to wait with me in my office while he took the call.
Now, you stated you invited Mr. Khan. So did Mr. Khan have a choice in whether or not he could wait in your office?
Oh, absolutely. I mean, Mr. Khan was free to go back to class, ask Mr. Testafay for a pass, or to wait with me in my office and get this resolved more quickly.
Your Honor, at this time, I'd like to introduce Exhibit E, Part 5. Let the record reflect that I'm showing opposing counsel a clean and unmarked copy of the exhibit. May I approach the witness?
You may.
Thank you.
Mr. Nowak, are you familiar with this document?
I am. This is the SRO Memorandum of Understanding, basically my job description.
And could you please read the 6th bullet point at the bottom of Exhibit E, Part 5?
Yes. Additional areas for continuing professional development may include, but are not limited to, student privacy protections and laws governing the release of student information.
So what does this mean?
This means that a large part of my job as SRO is to protect the privacy of the students at my schools, particularly when it comes to the release of their information in a school atmosphere.
Your Honor, at this time, I'd like to introduce Exhibit G. Let the record reflect that I'm showing the opposing counsel a clean and unmarked copy of the exhibit.
The record will reflect, so reflect.
May I approach the witness?
You may.
Thank you.
Mr. Nowak, are you familiar with this document?
Yes, this is a map of the administration suite where I work.
Could you please point out to the courtroom where Dean Silva's office is?
Sure. So Dean Silva's office is at the top of the page right there.
And could you please point out to the courtroom where your office is, the SRO office?
About 8 feet away on the other side of the hall right there.
And could you please point out where the copy machine is?
About 4 feet away on the other side of the wall right there.
So was there anything in the administration suite that could be a disruption to a conversation?
Yes, I mean, for me at least, the copier is a daily disruptance. It's on the other side of my wall. It's rather loud and annoying. It's hard to hear when it's running 24/7.
Was there anything else?
Yes, so across the way from Mr. Tesfay's desk is student seating, meaning that there could be a possible flow of students in and out of the administration suite at any given time, listening in on any conversations going on in either the dean's office, the principal's office, or my office.
So why did you feel it was necessary to close the door during your conversation with Mr. Khan?
Well, not only was the copier rather loud and disruptive, but I wanted to make sure that Mr. Khan's privacy and confidentiality was protected while he was in my office, as I am required to do.
And what did you and Mr. Khan discuss while in the SRO office?
We discussed the prank at large. Really, we were just biding our time until Dean Silva was ready to continue our conversation. I explained certain repercussions that whoever had committed the prank might face. It was all very hypothetical at that point.
And how did Mr. Khan react to this discussion?
He appeared to be visibly and verbally defensive rather than just absorbing the information that I was giving him.
And how did your conversation with Mr. Khan end?
Well, it ended after about 20 minutes when Mr. Khan's parent came to pick them up at the end of the day. I told them he was free to leave at any time and that he was not under arrest.
So at any point during your conversation with Mr. Khan while in the SRO office, did you put Mr. Khan into your custody?
Absolutely not. We were simply waiting for Dean Silva's conversation to be, or conversation on the phone, I mean, to be completed, and we were simply waiting in my office. Mr. Khan could have left at any time, as I tried to make explicitly clear to him.
Thank you. No further questions at this time, Your Honors.
Any cross-examination?
Yes, Your Honor. Good morning, Officer Novak. My name is Mohammed Khan, and I'll be asking you some questions on behalf of the defense today.
Good morning.
So starting off, it's true that as an SRO, you're employed by both the school and the police department, correct?
Yes, I like to think of my position as an SRO like an Arnold Palmer iced tea and lemonade.
Is that a yes, Officer Novak?
Yes, it's a half and half position, a mix of the two.
Do you still have a copy of that memorandum of understanding?
I do. Let me grab it for you.
Let the record reflect that I'm showing opposing counsel a clean and unmarked copy of Exhibit E.
The record will so reflect.
So, Officer Novak, I'd like to start by taking a look at the very first page under Roman numeral 1, the end of the first paragraph. It reads, "The SRO shall serve as a law enforcement officer at the school and is not there for school discipline, which will be handled by the honor board and administrators of the school." I read that correctly, right?
I don't have the first page. I only have page 5.
Would you like a copy?
Yes, please.
Permission to approach?
You may.
Thank you very much.
Would you like me to reread that statement?
Please do.
So it says, "The SRO shall serve as a law enforcement officer at the school and is not there for school discipline, which will be handled by the honor board and administrators of the school." I read that correctly, right?
You did read that correctly, yes.
So based on this, it's true that your role at the school does not involve school discipline, correct?
Based on this, however, the SRO goes into detail how I may get involved in school discipline if necessary.
So occasionally you do overstep the boundaries of what this says, correct?
I mean, this one specific line, the SRO Memorandum of Understanding goes into detail about how, at the behest of the principal or the dean, I can get involved with school disciplinary issues.
So let's take a look at what it says about that. Would you like a copy of Exhibit E, Part 4?
Please. Yes, please.
Permission to approach?
You may.
I'll just hand you a folder.
Please. Thank you very much.
So under Part 4, Roman numeral 4, the fourth paragraph, it says, "The principal and the SRO shall use their reasoned professional judgment and discretion to determine whether SRO involvement is appropriate for addressing student misbehavior. In such instances, the guiding principle is whether misbehavior rises to the level of criminal conduct that poses real and substantial harm or threat of harm to the physical or psychological well-being of other students, school personnel, or members of the community." I read that correctly, right?
You did, yes.
And you got involved in the conversation with Stevie Khan on September 15th because you heard the students bickering, correct?
Yes, I wanted to make sure they were all right in the room, they were alone, it was a rather loud conversation, and I'm supposed to keep students safe.
So that conversation that you heard, that was actually just kid stuff like GPAs, correct?
Yes, in part.
So you felt that was enough of a threat for you to get involved, correct?
No, it was a rather loud and aggressive conversation. I wanted to peek my head in, since Dean Silva had left at that point, to make sure they were all right.
So regardless of the contents of the conversation, you decided to get involved, right?
Sure, yes.
Now, referring back to the Memorandum of Understanding under Part 5, the second paragraph at the beginning, it reads, "When the SRO or other police department employees have opened a criminal investigation, school personnel shall not interfere with such investigation or act as agents of law enforcement." I read that correctly?
You
right?
did, yes.
So now I'd like to talk about what you did on the day of the alumni breakfast. It's true that the first thing you did was speak to Dean Silva about the next steps in the investigation, right?
After the prank?
Yes.
Yes, I did.
And it's true that you also met with the dean a second time on September 12th, right?
I did.
And Blair Georgia was present at this meeting?
He was.
And Blair asked you if there could be criminal charges, right?
He was curious about what repercussions the prankster could face, some being criminal, yes.
And it's true that you told Blair that based on what the Blair and the dean found out, there could be criminal charges, correct?
Yes, I mean, our knowledge of the prank at that point was only really 1 day removed. Everything was very up in the air and
Novak, is that a yes?
Yes, like I was saying, it was all very hypothetical. At that point, it was simply school discipline, though.
So there was potential for criminal charges, right?
Potential, like I said, all very hypothetical at that point.
And these criminal charges were trespassing, battery, and destruction of public property, right?
Yes.
So now I'd like to talk about September 15th. It's true that when Blair came to the dean with information, you offered to talk to Stevie, right?
The dean was rather busy that morning with administrative duties, so I offered to talk with Stevie before school, so this didn't drag out.
You actually wanted to talk to Stevie so that you could catch them before the school day ended, correct?
I don't think any student likes to stay after school, so yes, I did.
So you did want to catch them?
Catch them before school let out, as in, like, make sure they didn't have to stay after school too long.
But Stevie did end up staying after school, correct?
Yes, for a little while.
And it's true, Officer Novak, that the dean did suggest that the both of you would talk to Stevie later on, correct?
Right. He said we would both have an opportunity to meet with Stevie later in the school day.
And you did end up meeting with Stevie, correct?
I did, yes.
And that's because you heard Stevie and Blair using the word evidence, right?
Yes, in part. The other part was it was a rather loud conversation, partially pertaining to the prank.
But the only reason that you entered the room was because of the word evidence, right?
Yes, that was a large part of why I entered the room.
No, in fact, that was the only reason, correct?
Sure, yes.
Now, Officer Novak, when you were in the office, you told Stevie that in the past you had charged kids with less, correct?
Yes, kids have been criminally charged with less before. Like I said, a very hypothetical circumstances I was laying out for him at that time.
So, Officer Novak, it's true that once the dean returned, you did not leave, correct?
Correct, yes.
And it's true that you actually participated by offering background on criminal charges once again, correct?
Right. It wasn't like I was offering any questions or other information, simply providing background to any questions they had for me.
So in a way, you were participating in the discussion, right?
Simply giving context for them, yes.
And you stated earlier that you were in the room because Blair and Stevie were getting a little aggressive, right?
Yes, that was in part, and in part, like you said, because they had referred to the prank and used the word evidence.
But in fact, you remained in the room even after Blair had left, right?
Correct. The dean said that we could both speak with him later in the day, so I figured this was as good a time as any.
And it's true that at no point did you explicitly tell Stevie that he was free to leave, correct?
At that point, it would have been the dean's job to do that.
But once the dean was actually gone, you were the one who took Stevie to your office, correct?
I invited Stevie into my office, and at this point, I made it clear to him that he could choose to stay or leave by inviting him to wait in my office.
Now, Officer Nowak, you say you made it clear, but you never explicitly stated that Stevie could leave, correct?
I never used the exact words, Stevie, you can leave now, but I offered for him to wait in my office, and in that moment made it clear to him that he could choose to stay or leave.
Now, by simply inviting Stevie, you can't be 100% certain that Stevie knew that he could leave, correct?
No one person can be 100% certain of the mindset of any other person at any given time.
But regardless, because you didn't explicitly state that, you couldn't be certain that you conveyed it to him, correct?
No, I felt that I had because Stevie was a very smart student, but I couldn't be 100% certain.
Now, I'd like to take a look at the administrative suite. Do you still have a copy of Exhibit G?
I think it's buried here. Give me a sec.
Let the record reflect that I'm showing opposing counsel a clean and unmarked copy of Exhibit G.
Record will so reflect.
So in this area, there's also a secretarial suite, correct?
Yes, there is.
And there's a conference room on the right side?
Yes, there is.
And you have access to both these areas, correct?
Yes, unless there's a meeting going on in either of those areas at any given time.
So you stated on direct examination that you took Stevie to wait for the dean, right?
I did, yes.
But you did not choose to take Stevie to either of those places?
No, I wasn't sure if there were reserved or if events were going on in there at that time.
But you didn't check, correct?
I didn't check. My office was open, so I figured we might as well wait in there.
So you made the decision to take Stevie to your office and close the door, correct?
Correct. It's a comfortable space. I felt he would feel secure there.
And once again, in your office, you told Stevie about possible criminal charges, right?
He was asking me a lot of questions about the prank, so I thought I would elaborate and
Officer
explain
Novak,
the
is that a yes?
repercussions. Like I was trying to say. He was asking questions, so I thought I would elaborate on what I was telling him earlier. Yes.
And eventually, Stevie left with his mother, correct?
Yes, she came to pick him up.
But it's true that at no point had Stevie's mother, to your knowledge, been notified that questioning was going on, correct?
Not to my knowledge. That is Mr. Tesfay's job, so it would be up to him.
Now, the next day, Stevie was criminally charged, correct?
Yes, the next day he was.
And Stevie was charged with criminal trespassing, battery, and destruction of property, correct?
Dean Silva and I had figured that the statements he had given us at that time were enough to give it to the police department, so we did.
So that's a yes, Stevie was charged with that?
He was.
And those are the exact same charges you had mentioned to Blair Georgiou earlier, correct?
Yes, they were.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Mr. Nowak, what role do you play in school discipline?
Well, at the behest of the principal or the dean, I can take part in school disciplinary issues that pose a possible threat to the physical safety of the students in the school.
So why did you get involved with the conversation in Dean Silva's office between Mr. Khan and Blair Georgiou?
Because Dean Silva had met with me. We've both had preparation in dealing with pranks in the past, and at that time it was a school disciplinary issue in which he needed help.
So at any point during the conversations between you and Mr. Khan or Dean Silva and Mr. Khan, was there an active police investigation open?
Oh, Lord, no. This was simply a school disciplinary issue at that time.
So why did you offer background for possible criminal repercussions of the actions on the prank?
Well, it's part of my job to give context to students of possible repercussions they could face. Like I said earlier, it was all very hypothetical at that point.
And you never explicitly told Mr. Khan that he was free to leave. Why was that?
Because I didn't feel it necessary at that time. I was simply laying out possible repercussions that the prankster could face. And by inviting him into my office, I felt that I had already covered it.
Now, you have stated multiple times that you made it clear to Mr. Khan that they were able to leave. How did you make it clear to him?
By inviting a very smart student like Stevie Khan into my office, I felt that they knew that they were free to leave at any given time.
And why did you close the door during that conversation between Mr. Khan and yourself while in the SRO office?
I'm required to protect student privacy. I was just doing my due diligence in my position.
Thank you. No further questions at this time, Your Honors.
How much time is there left for recross?
20 seconds, Your Honor.
Okay, any recross?
Very briefly, Your Honor.
Okay.
Now, Officer Nowak, I just have one question for you. It's true that if you had started a formal criminal investigation, Dean Silva would not have been allowed to get involved, correct?
I don't believe he would have been involved if it was a formal criminal investigation. That's why
Thank
he
you.
was.
No further questions, Your Honor.
You can step down.
Thank you, Your Honor.
Is the state resting in the presentation of evidence?
At this time, Your Honor, the prosecution rests.
Okay. And defense?
Yes. The defense calls Stevie Khan to the stand. Good morning, Stevie. Could you please start by stating your name, spelling the last for the record?
Good morning. My name is Stevie Khan, Khan, and just to clarify, I have no relation to my attorney.
How old are you, Stevie?
I am 16 years old.
Do you attend school?
Yes, I am currently a junior at Trillium High School.
At Trillium, are you involved in any extracurriculars?
Yes, I'm on our school's basketball team. It's a good thing. I absolutely adore academics because I'm only 5'9", and plus my mom's a science teacher, so it's a lot to live up to.
So, Stevie, I want to talk to you a bit about your school situation during the COVID pandemic. Were you attending in person?
Last year, it was a hybrid between in-person and online, so this year is fully in-person, so it was very difficult for me to fully adjust to being in person 5 days a week.
Now I'd like to talk to you about the alumni breakfast. Are you familiar with that event?
I actually am. They invite the top 10 students in each grade, and last time I checked, I was number 1. Plus, it's a fundraiser for our school's sports team. So I was also there representing the basketball team as well. I was really excited at first to have a nice meal with my mom and dad, but things went south very quickly.
Could you elaborate on that?
Someone put exploding candy into the eggs.
Stevie, has this happened before at your school?
It actually has. It's all over Trillium. It's like a very popular trend there. Me and my friends do it to each other during lunch. Someone did it to a Friday grill out that the school hosted prior to the alumni breakfast incident. And plus, during family movie night, I sprinkled some exploding candy on my mom's Cheez-Its. However, it was all in good fun, and we all had a good laugh about it.
Stevie, do you know why you're here today?
I do. I'm here because I was interrogated for over 2 hours by a dean and a police officer about my involvement in the alumni breakfast incident when I had absolutely nothing to do with it other than being a victim of that incident myself.
So, Stevie, was this the first time you were questioned about the prank?
Actually, it was not. On the night prior, so September 14th, I was called in front of the honor board for a hearing.
Why were you at this hearing?
I made a mistake. I cheated on a take-home APUSH test. We were only supposed to use our textbook, but I Googled one of the dates during the test. March 5th, 1770. I'll never forget that date now.
Stevie, does this have anything to do with the alumni breakfast?
It does not.
Then how was it brought up?
The person that was asking majority of the questions during the honor board, Blair Georgiou, who is a fellow student of mine and academic rival of sorts, started asking me questions about what I was doing the night prior to the alumni breakfast incident.
Did you answer these questions?
I did not.
Why not?
Well, Blair is a classmate, they're my academic rival of sorts, and plus they're on the basketball team with me, so they're a teammate as well. And Blair is 16 years old and not an adult by any stretch of the imagination. So I felt like I didn't have to answer their questions on the same level as I had to answer an adult's.
So, Stevie, when was the next time you heard about your potential involvement?
I heard about my involvement the next day on September 15th. It was about 1:30 p.m. I was just finishing up some classwork. Then the dean walks in and calls me to their office, and then they walk me down to their office.
Did you know why you were being pulled out of class?
I thought I did.
Could you elaborate?
I thought I was being called down by about the test that I cheated on, and more specifically the honor board meeting the night prior. It started off that way, however, it quickly transitioned to the dean interrogating me about what I was doing the day of the alumni breakfast incident.
Stevie, when you found out that this was happening, how did you react?
I asked the dean if I could go back to class.
How did the dean respond to that?
They said, it'd be better if you just told me what happened.
Now, Stevie, since you had to stay, how did the dean proceed?
The dean just kept on pressing on about the alumni breakfast incident, like what I was doing during the day. And I asked them, I told them I do not want to answer any more questions about this. And I asked for a second time if I could go back to class.
So, Stevie, when you asked to leave a second time, how did the dean respond?
The dean flat out ignored me and called for Blair Georgiou, who was asking the questions the night prior.
What happened when Blair got to the office?
Blair accused me of some outrageous things, like how I practically poisoned people and how I almost killed his grandmother.
Did the dean ask any more questions at this point?
Yes, the dean asked how I got the exploding candy for the eggs.
How did you respond to this?
I was really confused, and I suggested to the dean that it could have been a staff member that could have done this incident.
How did the dean respond?
The dean actually corresponded to my idea and went to ask some after-hours staff about something. When I tried to get up and leave because I thought it was over at this point, the dean told me to stay where I was in their office.
Stevie, since you had to stay once again, did anything happen when you were alone with Blair?
Yes, Blair kept on confronting me about the alumni breakfast. They suggested to me that a police officer told them that I could be charged with criminal trespassing.
Objection, Your Honor. Hearsay.
Response?
Yes.
This statement is not being offered for the truth of the matter. Whether or not, at this point, Stevie could be charged with criminal trespassing doesn't go towards if a custodial interrogation took place. Rather, it goes towards the effect on the listener. Stevie Khan.
Your Honor, this is being offered for the truth of the matter, as there were criminal implications to the alumni breakfast incident, and therefore the effect on the listener hearsay exception is not applicable at this time.
I'll give you a last word.
Yes, Your Honor. Again, whether or not at this time there actually could be criminal charges does not contribute to the objective circumstances of the questioning itself, and therefore it solely goes towards the effect on the listener, Stevie Khan, and how he may have been feeling in that environment.
Objection is overruled.
Thank you, Your Honor.
So could you repeat what Blair told you?
Yes, Blair told me that a police officer said that I could be charged with criminal trespassing.
Did the dean return eventually?
Yes, they did. They arrived about 20 minutes after they left, walking in the room saying, "It's time to fess up. Tell me what you did."
Stevie, was it always just you, the dean, and Blair, or did anyone else ever show up?
Yes, at about 2:45, I noticed a police officer blocking the doorway of the dean's office.
How did you know it was a police officer?
They had the whole 9 yards. They had the uniform, they had a badge with their last name on it, which was Nowak. They had handcuffs. They even had a firearm on them.
Had you ever seen this police officer before?
I've seen them around, however, I've never had an interaction with them prior to this point.
Did the officer say anything to you?
Yes, they mentioned that they've charged kids with lesser crimes.
So, Stevie, earlier you mentioned you were on the basketball team. Did you have practice that day?
Yes, as always, we have basketball practice at 3 p.m. after school, and Blair is on the basketball team with me, and they're still in the room at this point. And they asked the dean if they could leave to go to the basketball practice, and they were allowed to do so.
Did you try to leave as well?
I did, but Officer Nowak said, "No, I think it's time you answer some questions."
So, Stevie, at this point, how long had you been answering their questions?
An hour and a half at this point.
Since you had to stay once again, how did the questioning proceed?
Well, I tried to explain to the dean and Officer Nowak that I've only heard rumors on the internet, and that's where Dean Silva asked if that's how I knew that the cafeteria doors were unlocked to the Trillium High School.
Around how long did this whole conversation last?
About 20 or so minutes, give or take.
What happened then?
Well, before I could explain to them that it was only on the internet, They got a very important phone call, and they asked for some privacy. And Officer Nowak took it upon themselves to escort me to their office, sit me down in a chair, and close the door behind them.
Did the officer say anything to you at this point?
Yes, they said, "Tell me what you did, and we can all go home."
How did you respond to this?
I said, "How is this even a crime? You can't break into the cafeteria, you can't break into a building if the doors were unlocked."
How did the officer respond to that?
They said, "How did you know the cafeteria doors were unlocked?" Which I didn't think was fair, because the dean almost said the exact same question less than 15 minutes beforehand. And the officer was in the exact same room in which that question was asked.
Stevie, do you remember anything else worthy of note that the officer said to you?
Yes, when I tried to explain to the officer that I've only heard rumors on the internet and like absolutely nothing concrete whatsoever, the officer said, "I'm not talking about what people are saying, Stevie. I'm talking about what you did."
How did you respond to this?
I said I wouldn't risk my reputation on making some stupid video.
So, Stevie, do you remember if Officer Nowak ever mentioned criminal charges to you in the office?
They did. They told me that what I did was criminal trespassing.
Were you ever allowed to leave?
Not on my own. Eventually, my mother, who is a science teacher, when she opened the door, the first thing she asked was, "Is my child being charged?"
How did Officer Nowak respond?
Officer Nowak said, "Not yet."
Stevie, what happened in the days that followed?
The literal next day, the police apparently got a search warrant for my cell phone, my cell phone's password, and my locker. And upon searching my locker, I was arrested immediately for destruction of public property, criminal trespassing, and battery.
Thank you. No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor. Good morning, Stevie. I'll be asking you a few questions today on behalf of the state.
Good morning, sir.
You had attended the alumni breakfast on Friday, September 9th, correct?
That is correct.
And it was just after this alumni breakfast that you were required to appear before the honor board, or that you had got caught cheating on a test, correct?
Yes, it was shortly after the abrupt end of the alumni breakfast.
And because of this, you were required to appear before the honor board?
Yes, about 5 days later.
Now, at this honor board hearing, you were asked questions about where you were the night before the breakfast.
That is correct.
And you had said, and I quote, "I know my rights," didn't you?
I did. I said that because Blair, who was asking all the questions, is a student and a minor, so I felt like I didn't have to answer their questions on the same level as an adult.
So you knew you didn't have to answer certain questions, isn't that right?
Yes, because Blair's a minor.
Now, the next day, you were called down to Dean Silva's office to talk about your cheating incident and the alumni breakfast, weren't you?
Yes, however, it was mostly about the alumni breakfast.
However, when Dean Silva got down there, he had tried to close the door, didn't he?
That is correct.
But when you wanted it left open, he willingly complied.
Yes.
Now, Dean Silva, you were very defensive during your talk with Dean Silva, weren't you?
Yes, because I was literally, my freedom could have been on the line. Like, I felt like I had to defend myself in one way, but I still felt like I had to answer their questions.
Now, during this conversation, Dean Silva had told you that it was Blair who accused you of pulling this prank, didn't he?
Yes.
And it was at this point that you suggested Dean Silva go question the cafeteria staff to see if they might know anything.
Well, that's not what prompted me to suggest that it could have been a staff member.
Yes, regardless, it was at this point that you had suggested to him to go question the cafeteria staff.
Yes.
Now, when Dean Silva left, you and Blair started talking. Isn't that right?
Yes, that is correct.
And it was at this point that you had said, "What are you going to do? Expel me over some exploding candy."
Yes, this entire situation is insane.
Now, Dean Silva had returned to his office around 20 minutes later.
Yes, entering the room saying, It's time to fess up. Tell me what you did.
And at 3 o'clock, Blair Georgiou had to leave for basketball practice, of which you're on the same team. Isn't that right?
Yes, Blair was allowed to do so, allowed to leave, and I was not.
Now, Blair's the same age as you.
Yes.
Blair is in the same grade as you.
That is correct.
Blair was in the same office as you.
Yes, however, they weren't being questioned on the same level that I was.
And neither of you left the office or the school at any point during this conversation with Dean Silva.
Yeah, well, Blair never explicitly asked to leave until basketball practice started. And I asked to leave 3 other times prior to this point. However, I was denied all 3 times.
I'm sorry, Mr. Khan, I don't think you understood my question. I was asking, had you ever left the school building at any point during this conversation?
I did not. I was not allowed to do so.
Now, Dean Silva had to take an important phone call around 20 minutes later. Isn't that right?
Yes.
And SRO Nowak had invited you over to wait in his office, didn't he?
I'd say invited is a completely different word. They escorted me to their office.
Regardless, you still chose to go wait in his office.
I felt like I had to.
Now, when you got into his office, SRO Nowak had closed the door, didn't he?
Yes, that is correct.
Yet you never asked him if he could leave the door open.
No, I was afraid. I was really scared.
So with one school administrator, you felt free to ask for the door to be left open, yet with another school administrator, you did not.
Yes, because with the first school administrator, I thought it was not about the alumni breakfast. I thought it was about the test that I cheated on. But with the second, I knew what I was being interrogated about. So I did not feel comfortable asking for the door to be left open.
Regardless, you did not ask for the door to be left open, did you?
Yes, because the scenario was almost completely different.
No further questions at this time, Your Honor.
Yes.
Stevie, I just have one more question for you.
Yes, sir.
Opposing counsel stated that Officer Nowak invited you to his office. Could you say exactly what Officer Nowak told you?
Officer Nowak escorted me to their office, sat me down in a chair, and closed the door behind them, and then prompted the conversation by saying, just tell me what you did, and then we can all go home.
Thank you. No further questions, Your Honor.
Any recross?
Yes, Your Honor. You still chose to go to SRO Nowak's office, didn't you?
I felt like I didn't have a choice in the matter. I felt like I had to go with them.
And when SRO Nowak closed the door, you never asked him for it to be left open, did you?
Yes, because I was very uncomfortable, and I did not feel like I was too scared to ask if I could if they could open the door.
Yet you had full ability to ask, did you?
I was too afraid to.
Thank you, Your Honor. No further questions at this time.
You can step down.
Thank you, Your Honors.
The defense would like to call Adrian Sato to the stand.
Good morning.
Good morning, Ms. Sato. I'd like to ask you a few questions on behalf of the defense.
Good morning.
Could you please state your name, spelling the last for the record?
Yes, my name is Adrian Sato, S-A-T-O.
And Ms. Sato, are you employed?
Yes, I'm currently employed in Harmony at both a local hospital and also at Trillium High School. Both are as a counselor.
How long have you worked at Trillium High School?
I've worked there for half a decade now, so 5 years. And before then, I've also had jobs at other high schools for varying amounts of time.
Do you have any qualifications to hold that position?
I do. In 2004, I got both my master's in social work and also my licensure in clinical counseling.
And what is it like being a clinical counselor at a high school?
A lot of it is just trying to talk to students and connect with them so I can give them the best possible care that I can provide.
Now, Ms. Sato, do you keep up with research in your field?
I do. Ever since my master's, where I spent a 1-year tenure as a research clinician in adolescent brain development and adolescent counseling. I found it really important to keep up with research, papers done, and any studies that have been published.
Why is that important?
It's important to me because the better The more knowledge I have on how adolescents develop and how their brains work, the better advice and help I can give them.
Now, Ms. Sato, have you ever come across any research pertaining to interrogation techniques?
I have actually. It's a really highly studied field.
Your Honors, pursuant to Rule 702, the defense moves to recognize Adrian Sato as an expert in clinical counseling and adolescent brain development based on her education, experience, and training in the field.
State's position.
Your Honor, the state does not contest the defense's motion to have them classified as an expert in school counseling, as that is the area they worked for 19 years. However, brain development the witness does not have adequate background in brain development, as they only spent 1 year in a clinical setting, and simply staying up to date on that would not meet the qualification of Rule 702, which is specialized experience more than the average person.
May I respond?
Yes.
1 year of concentrated research on adolescent brain development is more than the average person. In addition, they aren't just keeping up to date with these articles, they're continuously applying what they've learned from these articles to their job as a counselor. Therefore, it is adequate.
May I respond?
Sure.
The 1 year of clinical experience that the opposing counsel continues to mention was 19 years ago while they were receiving their education, and 1 year of experience 19 years ago and simply staying up to date would not have given them enough understanding of brain development, as it is an ever-going and on-developing field.
May I respond?
Yeah.
19 years of continuous reinforcement is plenty, ample experience.
Objections overruled.
Thank you. So, Your Honor, to be clear, he is an expert in both brain development and adolescent.
That is correct.
Thank you.
To be clear, is it adolescent counseling or clinical counseling that Ms. Sato is recognized as? I moved for clinical counseling.
And what was your position on that?
We raised no objection to the clinical counseling, as that's where they've worked.
That's what I thought.
Thank you. Now, Ms. Sato, based on your expertise in adolescent brain development, is the adolescent brain different from that of the adult brain?
Yes, it is. It doesn't actually stop developing until well into your mid-20s.
Could you explain some of these differences to the court?
I can. So, to save you a Bio 101 lecture, essentially, the adolescent brain is far more driven by instinct and impulse as opposed to an adult brain. This is due to the fact that the prefrontal cortex, which is our logic and reasoning center of the brain, is less developed. It's physically smaller. This can lead to them being more susceptible to things like coercion from peers or adults. That's why we talk about peer pressure a lot in schools, or anxiety symptoms of it.
So you mentioned anxiety. Is anxiety common amongst adolescents?
From my experience, yes, it is.
Objection, Your Honor. Relevance.
Your Honor, this is going directly to the definition of an average adolescent. If anxiety is common, that can bring Stevie Khan and an average adolescent closer in similarity.
Pursuant to Burke v. McCarty, they stated that the only line of inquiry that is relevant is how a reasonable person would react. Later, in Ray Howbeal expanded upon that ruling to include adolescents with with mental disabilities. In this case, anxiety or claustrophobia would have no bearing on today's issues.
If that is the case, then that's fine, yeah. I still believe that it is relevant because it is directly relating to Stevie Khan and their situation on September 15th. Therefore, I hold my position.
Sustained.
Thank you.
So, Ms. Sato, are you familiar with Stevie Khan?
Yes, I am. He is a student I give counseling to at Trillium.
And are you aware of an incident that they were involved in on September 15th?
I am. Stevie Khan was interrogated by a police officer and the dean of students.
And how old is Stevie Khan?
Stevie is 16 years old.
Now, Ms. Sato, do you believe that based on a reasonable degree of professional certainty, you could testify to a line of hypotheticals pertaining to not specifically Stevie Khan, but that of an average adolescent in a similar situation?
I believe I could, yes.
So, Ms. Sato, based on your expertise, if a dean of students walks an average adolescent down to their office without telling them why, how might that affect this hypothetical individual's state of mind?
Likely from my experience working with kids, especially in schools, They would feel confused because they're being taken down to the private office of a person with great authority over them for seemingly an unknown reason. So this could lead to feelings of anxiety or worry alongside that confusion.
And if this dean accused this adolescent of something, how might that make them feel?
Likely they would begin to feel defensive, especially if they know they didn't do what they're being accused of, because they want to prove their innocence. This person of power over them is telling them they did something that could possibly have repercussions, and they don't want to incur those if they know they didn't do something.
So if in this situation a school resource officer, an officer of the law, entered the office, how might that make them feel?
Likely that's going to make them a little more on edge, because a police officer entering the situation makes the student likely see it more as a criminal issue than simply school discipline. So they might feel more anxious or worried about their presence.
And if this officer of the law, hypothetically, brings up criminal charges, how could that affect this average adolescent's state of mind?
From my experience, it would likely make them feel very anxious, maybe even trapped, because now they're not just a student undergoing school discipline, they are a suspect of the law. They might feel compelled to answer any questions that are given to them by the dean or the police officer, whether they would actually want to answer them or not.
So,
Objection, Your Honor. I raised my previous objection of relevance when the witness stated anxiety in their answer.
the word anxiety can be stricken from the record. That's perfectly appropriate.
Does that satisfy?
That completely satisfies, thank you.
Your objection is sustained.
Now, moving on, if this school resource officer invited this average adolescent into their office, how might they feel?
They would likely feel obligated to follow the officer, because up until now they've been accused of things and told that they might be charged with things, so they might think that if they don't go with the police officer, that they will get charged anyways with something different because they failed to comply.
And if this officer of the law closes the door behind this adolescent, how might that affect their state of mind, hypothetically?
It would likely make them feel trapped in the situation, like they had to answer anything asked of them, and they could not leave.
So, Ms. Sato, throughout this entire hypothetical situation, in your professional opinion, do you believe that an average adolescent would have felt free to terminate the investigation?
No, absolutely not.
And do you believe that an average adolescent may feel compelled to make false, incriminating statements in order to escape the situation?
Yes, I do.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Good morning, Ms. Sato. My name is Gavin Addington. I'm representing the state in today's proceedings. Are you ready to proceed?
Yes, good morning.
Now, you stated that the adolescent brain is still developing well into the mid-20s, didn't you?
That is correct. There's been a lot of research done on it.
And you've also stated that that rate of development varies widely across the population. Isn't that right?
Oh, yes.
And you also stated that adolescents can still make rational decisions, can't they?
Yes.
Ms. Sato, do you have a CT scan of Mr. Khan's brain?
Objection, Your Honor. Relevance. Opposing counsel has already discussed mental illnesses and how they are not applicable in this case. Therefore, this is irrelevant.
Your Honor, I'm not discussing mental illnesses. I'm discussing the brain development, which this witness has been classified as an expert in.
Objection is overruled.
Thank you. I will ask that question again.
Thank you.
Ms. Sato, do you have a CT scan of Mr. Khan's brain?
No.
Do you have an MRI scan of Mr. Khan's brain?
No.
So due to the wide variation of the rate of development across adolescents, there is no way of knowing how developed Mr. Khan's brain was at the time of these questionings, correct?
Not like the actual development, but I've been counseling him for a while, so I have a general idea of how he acts and works.
But to be clear, you have no scientific way of knowing how developed Mr. Khan's brain is.
No, I am just his counselor.
Now, this means that you cannot be fully aware of how developed you cannot be fully aware of how capable Mr. Khan is of making rational decisions. Isn't that right?
I've known him for a few months now, or 1.5, excuse me. So I have an idea of how he acts around other people and how he might respond to situations.
But to be clear, you have no scientific way of knowing how capable Mr. Khan is of making rational decisions, correct?
Counseling can be considered scientific. I mean, clinical counseling is a scientific field. I don't need to be a neurologist just to say that.
But you do not have any diagrams or graphs or data sets, correct?
No.
And to be clear, Mr. Khan is a student that you consult at Trillium High School, correct?
Not consult, but I give counseling to.
Yes, and with your role as a school counselor, you do not have the authority to give medical diagnoses to students, correct?
No. All I can do is offer them another doctor to go to if I think they are fit for a diagnosis.
Now, it is because of your relationship with Mr. Khan that they came and told you about what occurred during the conversations between Mr. Khan, Dean Silva, and SRO Nowak. Isn't that right?
Who is they?
Mr. Khan. They came to you and they told you about what happened between these conversations.
Yes, because at the time he was feeling stressed and he wanted my help. So he told me everything and I helped him deal with the emotions.
And you have openly criticized school-based policies and practices, haven't you?
Yes.
And this is because it makes it more likely for students to be interrogated in a school setting, isn't that right?
That is correct. I don't think that has any place in a school.
And you were informed by Mr. Khan that these practices and policies that you criticize were the ones used in their conversations, correct?
Yes, because I was trying to help him.
More specifically, you were informed by Mr. Khan of what occurred during the conversation between Mr. Khan and Dean Silva, isn't that right?
That is correct. I needed all the information I could have to help him out.
And you were informed by Mr. Khan about what occurred during the conversations between Mr. Khan and SRO Nowak, correct?
That is completely correct.
Did you ever witness Mr. Khan's discussion with SRO Nowak?
Not personally. It wasn't my place.
Did you ever witness Mr. Khan's discussions with Dean Silva?
No, I did not.
Did you ever speak to any other administrators or students about what occurred during these conversations with Mr. Khan?
No, because I was solely there to help Stevie at the time.
So to be clear, you have no way of knowing what actually occurred during these conversations, isn't that right?
Not directly, but I don't see why Stevie would have lied to me because he wasn't trying to prove any innocence to me, just trying to get help.
Thank you. No further questions at this time, Your Honors.
Any redirect?
Yes, Your Honor. Ms. Sato, do you believe that you need a physical map of someone's brain to know how they work?
No, and even physical maps of brains can be deceiving. You can't diagnose things just from seeing a CT scan or an MRI scan. That's why we have counselors.
And why do you believe that Stevie Khan, why do you believe what Stevie Khan told you?
I believe it because he didn't have a reason to stretch the truth to me at all. He didn't know any of this was going to happen, neither did I. He was just trying to deal with a unfortunate situation. There was no innocence that needed to be proven.
Do you believe that you needed to hear other perspectives?
No, it wasn't my place, and I was solely focused on helping Stevie.
Thank you. No further questions.
Any recross?
Yes, briefly, Your Honor. Ms. Sato, regardless of Mr. Khan's motives, you were informed solely by Mr. Khan of what occurred during their conversations, correct?
That is correct. I've said that before.
And to be clear, you witnessed none of the events that we are talking about here today in trial, correct?
That is also correct.
Thank you. No further questions at this time.
You can step down.
Thank you, Your Honor.
Is the defense resting at this time?
Yes, Your Honor, the defense rests.
And counsel then will be allowed 2 minutes within which to prepare your final arguments. Counsel for the prosecution, you may make your final argument.
Opposing counsels, your honors, may it please the court. A prank was committed during Trillium High School's annual alumni breakfast. This prank occurred at Trillium High School, at a Trillium High School event, during school hours, and involved Trillium High School alumni, making this a school disciplinary matter. Dean Remi Silva acted within their capacity as a dean, following all of the standard procedures to get to the bottom of this school disciplinary issue. Additionally, the court heard today that School Resource Officer SRO Nowak performed their duties of informing students of the possible legal ramifications of their actions, as well as protecting students' privacy during confidential conversations. Now, the defense attempted to argue that the defendant was subjected to a custodial interrogation on September 15th, 2022, in which the defendant was not made aware of their Fifth Amendment right to remain silent, which is protected by Miranda v. Arizona. However, we, the state, have proven that this was just a conversation. The state has disproved the defense's claims through a preponderance of evidence we have displayed for the court today through both Dean Silva and SRO Nowak's testimony. Dean Silva's testimony outlined the proper procedure they followed in dealing with this school disciplinary issue, which in this case was the exploding candy prank. This included a conversation with the defendant, Mr. Khan, in which Dean Silva initiated and carried out without SRO Nowak being present. Additionally, Dean Silva proved to the administration meeting agenda that part of SRO Nowak's responsibilities involved dealing with the consequences of pranks committed at Trillium High School. Now, we have heard courts rule on issues similar to this, as seen by In re Tatiana R. In this case, a student was called down to the dean's office to discuss criminal accusations, during which a school police officer was present and even asked that student questions. Those questions eventually led to that student's arrest. That same student later tried to suppress their incriminating statements because they believed they were subjected to a custodial interrogation. Tatiana ruled, as seen in our case today, that having a police officer present was standard procedure for addressing school disciplinary issues, and that police officer's presence did not create a police-dominated custodial atmosphere. Both of these factors have proven that in our case today, no custodial interrogation has occurred. meaning at no point was the defendant required to be read their Miranda rights. Furthermore, SRO Nowak testified that he is fully aware of the situations that require Miranda rights to be read, and a school disciplinary issue is not one of those situations. Mr. Nowak made it clear to the court that Miranda rights must be read during a custodial interrogation. Miranda v. Arizona defined custodial interrogation as questioning initiated by law enforcement after a person has been detained or otherwise had their freedom of action limited in any significant way. Mr. Nowak has proven to the court today that he did not detain or limit the defendant's freedom of action in any significant way. Rather, he protected the student's the confidential nature of the conversation, as he would have done with any other student. The Court of Ohio has ruled on an issue of this nature as seen by In re Haubiel. In this case, a student requested to appeal a judgment on the grounds that they did not knowingly, voluntarily, and willingly waive their Miranda rights. However, Haubiel ruled that Miranda rights were not required to be read, as a school setting was ruled non-coercive, and the court found no evidence that the student was not free to leave at any point during their discussions. Today, the defense has failed to show adequate evidence that Mr. Nowak had detained or otherwise limited the defendant's freedom of action in any significant way. As we heard, Haubiel ruled that this would not constitute a custodial interrogation. While the defense attempted to show the unlawful nature of both Dean Silva and SRO Nowak's handling of the prank committed on Trillium High School's alumni breakfast, we, the state, have proven that all actions taken by both the dean and the school resource officer were well within the parameters of their respective roles as school disciplinary officials. The state has proven that Miranda rights were never required to be read in today's proceedings, as this was just a conversation. The state holds the burden of proof, and Your Honors, we have met this burden. We respectfully request that you rule in favor of the state and that all of the defendant's statements be made admissible. Thank you.
Defense counsel, you may make your final argument.
Yes, Your Honor. Your Honors, opposing counsel, may it please the court. When a student becomes a suspect and a schoolhouse becomes a station house, that student is entitled to the rights provided by the Fifth Amendment. In the case of In re Galt in 1967, the Supreme Court ruled that the Due Process Clause applies to juveniles. Today, Your Honors must determine whether or not a juvenile, Stevie Khan, was subject to a custodial interrogation through the reasonable person test. The court in JDB v. North Carolina ruled that age must be considered. Therefore, the ultimate question today is whether or not a reasonable 16-year-old in Stevie's position would have felt free to leave. The prosecution held the burden in today's case, but they failed to meet that burden, Your Honors, because the evidence cuts towards custody. Now, the prosecution claims that all that happened was a simple conversation. So let's take a look at what actually happened on that day. The factors that courts have long considered are the location, the language, and the length. First, regarding location. Opposing counsel mentioned the case In re Haubiel, which said that things in a school setting do not constitute a custodial interrogation. However, that case was over 20 years old. Time and time again after that, such as in In re AA, In re LG, and In re TAG, courts have ruled that a school can be a location where a custodial interrogation occurred. On September 15th, 16-year-old Stevie Khan was pulled out of the office by the dean of students and escorted to their office. Any reasonable 16-year-old in that position would not have felt free to leave, Your Honors. In fact, the only time that Stevie was allowed to leave the dean's office was when a police officer took him across the hall to their office, sat him down in a chair, and closed the door. Your Honors, the schoolhouse had become a station house. Now let's take a look at the language employed. Once again, opposing counsel continuously claims that all that happened was a simple conversation. Dean Silva, when Stevie first asked to leave, said, "It would be better if you tell me what happened." When the dean returned from questioning staff, they said, "It's time to fess up, tell me what you did." When Stevie tried to leave for basketball practice, a police officer told him, "No, I think it's time you answered some questions." When the officer had Stevie alone, they said, "Tell me the truth and we can all go home," along with, "What you did is trespassing." Your Honors, this is not a simple conversation. These statements were made with the purpose of incrimination, trying to make Stevie falsely confess. Now let's take a look at the length of the interrogation. Stevie Khan was interrogated for over 2 hours, 1 hour and 37 minutes of which took place after school had ended. After reviewing the totality of circumstances, we submit that a custodial interrogation began 15 minutes into the questioning of Stevie Khan, the moment when Dean Silva ignored Stevie's request to leave and began asking questions about the alumni breakfast. You heard today from Ms. Sato, an expert in the adolescent mind and clinical counseling, that a student in Stevie's position at 16 years old would have felt that they needed to comply with authority and they would have been coerced into falsely confessing. That is exactly what happened on September 15th, Your Honors. Our client was confronted by 2 agents of the state, one of whom was a licensed and uniformed police officer. Both agents of the state were required to Mirandize Stevie, but neither did so. Your Honors, in the past, schools have often employed school resource officers in order to keep their students safe. That's what happens at Trillium High School. However, as officers attempt to get involved in disciplinary matters, it can quickly turn into a custodial interrogation, especially if the dean of students is working closely with that officer. I mentioned earlier the case in Re TAG. In that case, the court ruled that a dean of students was an agent of the state because they conferred with the officer about possible criminal charges and felt that they had more leeway when questioning students. You heard today that not only did Officer Nowak actively participate in the discussion of criminal charges, but also that they didn't start a formal criminal investigation after evidence was collected. Your Honors, what's the point of a criminal investigation? It's to collect evidence. But Officer Nowak let the dean do the questioning and talked about criminal charges during it before any investigation was formally started. Your Honors, because a student became a suspect and a schoolhouse became a station house, we ask that you rule in favor of the defense and grant our motion to suppress. Thank you.
Thank you. Any rebuttal argument?
Yes, Your Honor. May it please the court. School disciplinary issues are just that, school issues. When a student pulls a prank on school property during school hours at a school event, they must face the school disciplinary actions that follow. The only expert for the defense was informed of what happened by the defendant and witnessed none of today's proceedings, which they admitted. The importance of the Sato emphasized the importance of Khan's anxiety and claustrophobia, the court heard no mention of anxiety or claustrophobia from the defendant themselves. The defense cited a multitude of cases, but failed to highlight that the law is not on their side. The multitude of cases that the defense rattled off were in no way similar to the circumstances of today's proceedings. Besides Miranda, all cases that the defense has cited are persuasive in nature. And in the case of Miranda, the overwhelming weight of the authority in Miranda is that warnings are not required in schools because the surroundings are, 1, familiar, and 2, because there's a need to keep order in schools. Now, based on all the evidence the state has proven before the court today, it is clear that in no way were Miranda rights required to be read. Based on all of these facts we have proven before the court today, Your Honors, we respectfully request that you rule in favor of the state and that all of the defendant's statements be made admissible. Thank you.
Thank you very much. At this time, the scoring judges will retire to begin deliberating, and then I will inquire regarding trial objections in just a moment.
Once again, you're watching the Ohio Channel and the 2023 Ohio High School Mock Trial Championship. We're coming to you live from the Thomas J. Moyer Judicial Center in downtown Columbus. The sponsoring organization for today's mock trial competition is the Ohio Center for Law-Related Education, which has been educating students about their constitutional rights and responsibilities through this program since 1983. After growing steadily over the past 40 years, it is the largest non-athletic competition in the state. Around 3,000 students participate, with more than 1,000 legal professionals volunteering as legal advisors, case committee members, and judges. The judges are still deliberating and scoring each team's arguments, and while they do that, let's hear from some of the students.
Okay, we have a student here with us from St. Edward High School. Do you want to introduce yourself and tell us what grade you're with?
Sure. My name is Seamus McGinty, and I'm a senior.
Seamus, how long have you been with the mock trial program?
This is my 4th year doing mock trial. I started as a freshman.
Excellent. And what would you say is your favorite thing about the mock trial program?
I really like talking about all the case law and figuring out what the best one is to use, and I like being a witness on cross-examinations.
That's excellent. What do you feel like you've learned the most from the mock trial program?
I think the biggest thing is being able to speak publicly and be able to be confident in front of a room of people and 7 intimidating judges even.
That is a challenge. So what would you say to a student, if you had a student considering joining mock trial, what advice would you give? What would you say to them?
I would say absolutely to join, and at first it's going to be really hard because none of it will make any sense, as a freshman at least for me. But as you go on, it gets a lot of fun, and if you do it with people the whole time, you'll really like it.
That's amazing. And do you have any plans for next year, for the future?
I'm not exactly sure where I'm going to college yet, but I think I'm going to be majoring in finance and then maybe do corporate law in the future.
That's amazing. Thank you so much.
All right, next person. Thank you. You can just stand on that X.
Perfect. More facing the camera. All right. Well, we have a Talawanda student with us. Do you want to introduce yourself, say your grade level?
Sure. My name's Elliot. I am a senior at Talawanda.
And how long have you been in the mock trial program?
All 4 years since I was a freshman.
That's amazing. And what would you say your favorite thing about the mock trial program is?
Just the group of people it brings together. My team is some of my closest friends, most amazing people. Our advisors are fantastic. So regardless of what we actually do at mock trial, which is also fun, the group of people is definitely my favorite part.
That's wonderful. And what do you feel like you have learned the most by participating in the mock trial program?
I think mock trial is unique in the way that it challenges people to consider all sides of an argument, whether or not that might align with your personal beliefs. My favorite example of that is when I was a freshman, our case had to deal with both Second Amendment and First Amendment rights, which required students to, on one side, defend the First Amendment rights of a student to talk about the Second Amendment, and on the other side, to try to remove that right. And so I think that was just, it's great in the way that it challenges you to consider all parts of an issue and how everyone might think about it.
That's awesome, and I remember those cases. Those are difficult ones. Yeah. So if you had advice for a future mock trial student who's considering joining, what would you say to them?
It's a lot of what you do in mock trial is presentation, and it takes a lot of confidence or pretending that you have confidence to stand up and do what you do. And I think a lot of when you're starting mock trial is just being confident in what you say, even if you're not, because if you can start out like that, the having strong facts behind what you're actually saying strongly follows. So, and which is why mock trial is also great at, teaching how to public speak and how to be confident about what you believe in.
How to be on camera answering questions impromptu. Well, thank you so much.
Thank you.
Speak into the camera and you can stand on the X.
All right, we'll have you introduce yourself, say your school and your grade level, please.
My name's Cody Wagner. I'm a senior at St. Ed's. And yeah.
Perfect. And how long have you been doing the mock trial program?
This is my 4th year doing it.
Amazing. So you've been doing it for 4 years. Hopefully you've learned a lot. What would you say your favorite thing about the mock trial program is?
The favorite thing for me is probably just the camaraderie in the team, and it kind of switches year to year, and it's necessary to be able to work with who you're grouped alongside, and that's really been the best part for me.
That's wonderful. So you have your favorite part, you've learned a lot. If you had to name one or two top things that your takeaway, what would you say you've learned the most from the mock trial program?
I've learned how to be, I guess, clear with people you're working with, that especially because if you're writing something on a notepad, you have to make it short and succinct, and it can't be confusing for your co-counsel. That's probably one of the things I've learned best, is how to communicate best with people you're working with.
That's wonderful. You've got some good teamwork going on. So if you had a student at your school or anywhere that was thinking about doing the mock trial program, what would you say, what advice would you give them?
I would say to make sure you know the law. There's a big aspect of performance in mock trial, but once you get down to the state competition, it certainly takes hold of the law, and you've got to make sure you know the case law very well.
And there's a lot of it sometimes. So do you have any future plans for what are you going to do next year?
So I'm going to Virginia Tech next year. I'm going to study sports media and analytics, but after that I've thought potentially about going in and doing criminal law. So
that's wonderful. This has helped you on, I hope. Thank you so much.
You can stand on the X and speak into the camera.
All right. So I'm just going to have you introduce yourself, say your school and your grade level, please.
I'm Eliza Sullivan. I'm a junior at Talawanda.
Perfect. And how long have you been doing the mock trial program?
I've been doing it since freshman year.
Okay, so a few years now. What would you say is your favorite thing out of that whole time?
I definitely love reading the case law and kind of formulating theories, and then also applying objections to that theory. It's a big game of chess, kind of,
Absolutely.
And that's a really fun part of it.
That's wonderful. So that's your favorite part about it. What would you say is the top one or two things that you've learned the most from the mock trial program?
Definitely public speaking and quick thinking. I think if freshman me could see me on TV, she would be like, what are you doing? I've definitely become a much more confident public speaker.
That's amazing, and you have the confidence to be here right now, which we appreciate. So if you had a freshman coming in or somebody considering doing mock trial for the very first time, what advice would you give to them?
It can definitely seem like a lot at first. There's a lot to learn, but trust your advisors, and it works out really well, and it's so much fun. It's worth it for everybody.
That's wonderful. And I know, so you have next year, do you have any plans for next year and beyond, or are you still figuring all of that out?
Right now, the hope is some type of international diplomacy or international political science degree, and then after that, who knows?
So this will help your working teamwork and doing both sides. That sounds great. Thank you so much. All right, we'll have you introduce yourself and your school and your grade level, please.
I'm Luke Stewart. I'm a senior at St. Edward High School.
And Luke, how long have you been doing the mock trial program?
All 4 years now.
Okay, that's a long time. So what would you say your favorite thing out of the 4 years has been about mock trial?
My favorite thing is just working together with all the guys. It's a great group of guys and a fun time that we have. And it's also fun just dissecting the case as a whole.
I'm glad you like the cases. We work really hard on them. So what do you feel like, not is just your favorite part, but what do you think you've learned the most? It could be a top one or two things that you've learned.
Probably like how to work with other people and make sure that you're on the same page and using the same case law or same wording in your directs or crosses to hammer in your themes.
That's wonderful. And so you've been doing this for 4 years. You're pretty well versed. If you had a newbie coming in or even your freshman self starting, what advice would you give to somebody that's considering joining the mock trial program?
Probably just don't be discouraged by the workload of it. It does seem like it's almost an extra class you're taking on at first, but it's a fun time, and just find a way to have fun with it and make it like a family.
So going on, do you have any future plans? And even if it's not in the law, do you think mock trial has helped you prepare for those future plans?
I do. I'm pursuing a degree in mechanical engineering, and then possibly looking into patent law as well. And mock trial just has taught me how to work with others and work as a team as a whole.
That's wonderful. Thank you so much.
Thank you.
Okay.
Stand on the X and speak into the camera.
All right, welcome. We're going to have you introduce yourself, say what school you're with, and what your grade level is.
My name's Muhammad Khan. I'm from Talawanda High School, and I'm a junior.
All right, and how long have you been doing the mock trial program?
I've been doing mock trial since freshman year, so this is my 3rd year.
Okay, so all 3 years. What is your favorite thing across the program that you've taken away from mock trial?
I guess my favorite thing is definitely like working with my teammates during practices, during trial. I like to think that we're pretty interconnected mentally during the trial because we talk to each other, we write notes and things.
You rely on each other.
Yeah, and I love also going through case law and things like that.
Wonderful. So what do you think has been the biggest learning experience or biggest learned moment for you from mock trial?
I think mainly mock trial is a good way to build confidence. I guess before joining mock trial, I wasn't too into public speaking, but ever since doing mock trial, it's been pretty much a passion of mine. And also, I never was really passionate about the law until I joined mock trial, so it really did change my life in a sense.
That's amazing. So do you think you're going to continue next year?
Oh yeah, definitely.
Wonderful. Thank you so much.
Thank you.
Step on the X and speak into the camera. This is our last interview.
Perfect. All right. So I'm going to have you say your name, school, and grade level.
Ethan Costco, St. Edward High School, and I'm a senior.
Okay. And how long have you been doing the mock trial program?
I've done it all 4 years.
Fantastic. So 4 years, lots of trials, lots of competitions. What is your favorite thing about the program?
Honestly, just like the skills it helps you build, like public speaking, confidence, things like that. I mean, when I started, I was much worse at like public speaking. You know, I wasn't like there, and it's just really helped me, especially like going into the real world now and things like that.
Talking to a camera and somebody you've never met before. So what do you feel like you've learned from mock trial?
I feel I've learned a lot of skills that I'm going to take into any career that I go into, especially with like the public speaking, the confidence, things like that, and just learning how to talk to people and things like that.
Wonderful. So hopefully that will serve you well moving forward. Do you have any future plans?
I do want to go on a pre-law track in college, but we'll see.
Well, good luck with everything. Thank you so much. Okay. Sure, come on in. Thank you so much. Go ahead and say your school and your grade level and your name.
My name is Will Salzarillo. I'm from Talawanda High School, and I'm currently a junior.
All right, and Will, how long have you been doing the mock trial program?
Since my freshman year.
Okay, so all 3 years then. And what is your favorite thing about it? You can pick a few.
I just love meeting so many people from all around Ohio. I mean, so many people are really nice.
Oh, good.
And I'm especially with the bonds I've made along the past 3 years, they're really fun. Some of my best friends are in there.
That's amazing. So you've had really good relationships, experiences. What do you think has been the biggest learning moment? What's your biggest takeaway?
I don't know, just like learning about the law. I think that's very important for pretty much everybody, and I just think that's very important.
Excellent. Well, thank you so much, and have a great day.
Thank you. You too.
Do you want to go back?
We can do two. We'll do all three. That's fine. Quickly. No, you're fine. No, don't apologize. I'm glad you're here. So I'm going to have you say your name, school, and tell me how long you've been with the mock trial program.
My name is Kate Bolenbaugh. I'm at Talawanda High School, and I've been here for 3 years, freshman, junior, and senior year.
That's amazing. So it's 3 years is a long time in mock trial terms. So what would you say out of all that time is your favorite thing about the program?
Probably the community, because our coach, Waxy, does a really good job of making sure that we're all like really good friends and working really hard together. There was this one time in freshman year where we all got dinner together and ate it all during practice, and it was such a memorable moment.
That sounds lovely. So you've had really good relationships. What would you say has been the biggest learning moment? What did you take away from the program?
Probably the biggest learning moment is just trying to think on your feet and talking, trying to trust your attorney, because in freshman year I had kind of a hard time of that, but now I've gotten a lot better of thinking on my feet and responding appropriately.
That's amazing. So last question is, if you were talking to somebody considering starting the program, what would you say to them?
Definitely do it. You don't have to be a lawyer to do it, but I will say it is a big time commitment, so be aware.
Wonderful. Thank you so much.
Thank you.
So just step on the X and speak into the camera.
All right, welcome. So I'm going to have you introduce yourself, the school you're from, and your grade level.
All right. My name is Daniel McNamara. I'm from St. Edward High School, and I'm a senior.
Perfect. And have you been doing mock trial that whole time? How long have you been in it?
This is my first year.
Oh, your first year? Welcome. So in this last year, what would you say is your favorite thing about the mock trial program?
I think it's just like kind of how holistic it is. Like my mom was a speech and debate coach for a while, and my sister did debate. And mock trial covers really everything. You have a speaking point, you have a critical thinking point, you have writing, you have case law too. It's a lot of different boxes you have to check, and it's very fun.
That's great. It's a holistic view. I like that. So you've learned a lot, it sounds like. Can you give me maybe your top learned moment takeaway from mock trial?
So the first inter-squad scrimmage we did is we faced our other team, and it was not pretty at all. And it was a humbling moment, and you definitely learn a lot. You figure out what hearsay means. That's a big
tough one.
Yeah. But probably that.
That's perfect. So since this is your first year, you have a unique perspective. If you had somebody that was thinking about getting started at any grade level, what would you say to them?
I think if you're interested, then try it. Like, what's the worst thing that could happen? Try it, see how it goes, and you'll probably be pretty good if you put in the work.
That's great advice. Thank you so much.
All right, thank you.
Thanks.
So just stand on the X and speak into the camera.
All right, welcome. I'm going to have you introduce yourself, your school, and your grade level, please.
Sure. So my name is William Plavin Masters. I'm from St. Edward High School, and I am a senior.
And have you been doing mock trial the whole 4 years? How long have you been doing it?
No, so our coach, Ms. Fairfield, convinced me to do it in my history class last year. So.
Okay, so this was your first full season doing it then?
No.
Oh, no, you did do it. Okay. So what's been your favorite thing over the last 2 years?
Kind of just the team building aspect of it. I mean, like, it's like sports in that you build a big camaraderie with the people that you work with. And besides that, you get a general feel for how law works, and I'm trying to go into law, so it's kind of fun.
That's great. You answered one of my questions, so you're going to go into law. That's wonderful. So what would you say if you had a student, even if they weren't thinking about a career in law, that was thinking about doing mock trial, what advice would you give them?
I would say mock trial is not strictly for those who want to go into law. Mock trial helps you build your people skills. In the past 2 years, it's helped me kind of break out of social anxiety, speak with others, and kind of grow as a person. And it helps you just grow your ability to perform in front of an audience also.
And I do have one more. So you're going into pre-law, but do you have any other plans? Do you know where you're going for next year?
Oh, absolutely. So I went early decision to Oberlin, which is a good school for pre-law, and I'm deciding on whether I should double major in psychology and pre-law or just major and minor in them.
Well, best of luck in whatever you choose. Thank you so much.
Appreciate it.
And that's all we have from the students. We're going to learn a little bit more about OCLRE, the organization putting on this program.
We are going to make some comments, and we will do this the same order that we did earlier. We'll start from the right side, come down to me, then start from the left side, and then my comments will probably be the briefest, and they will be the last. So go right ahead.
You guys did a phenomenal job. Thank you so much for the opportunity to judge this. I have been judging mock trial for a number of years, and when I told you what I did in my current position, what I didn't mention is I was the elected prosecutor in Delaware County. My favorite thing in the world to do, and my place to be, besides with the grandkids, is in the courtroom trying cases. So it was phenomenal to watch you guys both present the case on behalf of the state and behalf of the defendant, and the passion and fervor you put into your positions. I cannot imagine the work you have done. I went back there and said, I'd put out a couple job offers if I were still the prosecutor. You have a little bit farther to go, 4 more years of college and 3 more years of law school. But no, I was super, super impressed. I guess you guys know almost what it feels like to wait for a jury to come in, because you get to hear all of us talk before you find out, right? Again, thank you, and good luck with all your future plans. How many of you guys plan to be lawyers? Okay. Well, and the witnesses, by the way, wow. If I only had witnesses prepped and as good as you guys were. So for those of you who want to be lawyers, this is the best you're ever going to get. So, thank you.
Yeah, you guys blew me away. It was terrific to watch you, and I love how you both sides took a theme and just went with it. This is just a conversation. That's the prosecution's theme, I suppose, and it was great, and I believed you. And then when you guys got up and you were like, no, 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 when the schoolhouse becomes a station house and when a student becomes a suspect, then I was like, yes, absolutely, I believe you. So I loved that it was very clear that throughout everything, even with your witnesses, like everyone was prepped on the theme and you continued with it. And I think that really is something that probably makes for like a great championship round. Yeah, I thought the witnesses were terrific too. I believed all of you. I believed Ari was a school, is it Will was a school resource officer, and Matt was the principal or the dean, and super believable as a school counselor, like quirky school counselor. And yeah, I think definitely you completely seemed like a 16-year-old who had been interrogated. Oh yeah, I said that back in conference, and they're like, he probably is 16. So yeah, phenomenal job. And Mohammed, I loved your closing like so much. So.
I agree with everything that's been said previously. I work a lot with outside counsels and lawyers, and you wish the lawyers are as prepared as you guys are when they present their cases and they present their arguments to the court. Sometimes they are, sometimes they're not. But you guys did an excellent job, and the cross-examinations were very good, focused, really saw the hard work that all of you did, and you should both be very proud. Both teams should be very proud.
Go down to the end of this.
Okay. All right. One of the things I've already been sanctioned for is I did not mention that I also, besides being judge, I'm also president of the Ohio State Bar Association from a small county. So are your family here? You have your family here? Yeah. Well, let the family stand up for both teams. All of you should be exceptionally proud of what these young people have done, because if they in fact go to the profession of law, they will succeed without question. I know the AG's office has already got 2 of them under scope once you get to law school, so you already have a contract. The cross-examination and the direct examination with both teams was phenomenal. The witnesses did great. It was obviously that you prepared. One of the things that you'll look back on, I come from a very small community. We have 34,000 people in our community. In my high school, we had the largest graduating class was 57 people in Southeast Ohio. And one of the things that we did at my school, which was somewhat unique to the area, was we had oratory contest. But the oratory contests were all in Western Ohio. They weren't, none of them in Southeast Ohio. And we were the only team that did that. And I played sports, I played football, and then at 4:30 in the morning we had to be up to the school after the football game to go over to Dayton to do the speech contest. I absolutely detested that. I mean, you had to give your speech 3 times. But as I look back on it now, some 51 years later, those were some of the best times that I ever had in my life, and it really helped shape me in your profession. I hope to God that you do follow up with the fact that you do go into the legal profession, because all of you, including the witnesses, will be successful with this. I have judged the contest in Southeast Ohio, and they discontinued them in Southeast Ohio because they didn't have enough participation. And you guys, both teams, knocked it out of the park with regard to how the competition was that I ever saw. I saw some pretty pathetic presentations. Believe me, this was outstanding with regard to both teams and your witnesses. and the academic advisors and the legal advisors should have credit for that as well. So thank you for giving us a very viable and upstanding argument with regard to the cases here today. Thank you, because it's been very entertaining, I know, for all of us when we went back in chambers and talked. Thanks.
Not going to be a lot for me to add, I guess, at that point, other than just wow. I actually went back and looked at my notes, trying to keep my notes high school appropriate. I used the word dang 6 times in my notes as I went through it at various things throughout here. What a pleasure to see this level of competition. I'm going to mention a couple of specific things that I'm going to note. That at some point, judging 2 basketball players playing a high school pickup game is different than judging Michael Jordan and LeBron James at their height playing each other. You're going to be looking for smaller details when you get to that level, and we're at that level here today. But, part of this is I'm involved in community theater back in our community, and part of this is the sort of presentation, the witnesses, the acting, a 16-year-old nailing a 16-year-old. Are you 17 or 18? 17-year-old nailing a 16-year-old. See the acting involved there. That's necessary. The witnesses in this trial were just incredible. The ability to redirect, the ability to hold your line on cross-examination. More than once I heard some variation of, like I was saying. Those made it into my notes. That got a couple of dangs right there in my notes. Just I don't understand the question, to redirect the question back or to buy yourself a moment. Who is they in clarifying a question. Throughout the witnesses did an incredible job of not allowing the attorneys to pull you off your target or to get you to say something that you did not want to say. Even with the attorneys, though, there is a certain amount of presentation in what you're doing beyond your knowledge of the law and your ability to hold to the position you want to make in your statements. And we heard it earlier from the moment you started with when a student becomes a suspect and a schoolhouse becomes a station house. You had that theme consistently through, but it wasn't just the theme; it was the presentation, the getting up of when the way in which you presented that, and then held that to the end. The ability to present case law from memory, just immediately. And that was particularly, as the juvenile court judge on this panel, this is an issue that comes before me fairly regularly, actually, whether a juvenile is in custody for the purposes of statements that were made. And so it's always fun for me to hear this case law coming back. I have to end with the comment that the exchange about whether or not the counselor was an expert witness between both sides. I'm trying to remember, I think it was you on the prosecution side and on the defense side over here. That back and forth, because you made the objection, you made the response, you countered back again. In 2 decades of doing mock trial, was the best back and forth on law and presentation I think I've ever seen. It really highlighted how well prepared both teams were here.
Yes, that certainly was the cleanest I've ever seen a debate about an expert witness. This is the 7th time I've heard the case this year, but it's the first time that I was a scoring judge and could sit back and really take things in without being on the edge of being interrupted for an objection. But every time, in every case, whether I was a presiding judge or whether I was a scoring judge, I learned something, and I learned a lot today and learned a lot more about the case every time. You all dug things out of there that I hadn't noticed the other times. This was what I classify as a very clean presentation, which it should be at the state finals. And your demeanor, all 4 of you, excellent. This is how I really like to see attorneys perform. What you see on television is drama, but what you folks portrayed, all four of you, was excellent. Especially on cross-examination. I was always taught that on cross-examination, maybe even be a little sneaky, just to try to get things in, and not the overly dramatic presentation that you've seen on TV and the movies. You were, as has been said, you were very consistent with your themes. That's something I always look for. The conversation that you emphasized, and the schoolhouse versus station house that you emphasized. I thought that was excellent. And again, your knowledge of the cases was stellar. This is the best presentation I have seen this year of the cases, and using the cases in a way that might help you, and then turning it around when you felt that a case did not suit your position. So you all are to be congratulated.
My comments are going to be a lot the same, and so I won't try to repeat myself too much. The word clean has been used, and I thought of the word precise. So we're talking about the same thing. The reason that there weren't very many objections, at one point I didn't think there were going to be any objections in the trial, is because everything was precise. Your questions were asked properly. The witnesses gave answers that were within the bound of what they're allowed to do, and everybody knew what they were doing, which is really, really good. And one of the other, it's interesting because the only other trial I judged in the state competition was there were tons of objections. And I was not the presiding judge, but there were just so many objections that neither side could really make their case. And I think the fact that both sides presented your case following the rules, and you were focused on what you were trying to present. So the defense and the prosecution obviously have different arguments they're making. You were like a laser in presenting evidence and in your arguments, and even following up from the opening statements. So excellent performances on both sides. For the parents and friends and family members who are here, you should be obviously very proud of your sons and daughters, because they did a really good job. I had, out of my 4 children, I had 2 who participated in mock trial. I had another and 2 that ended up becoming attorneys. Only one of the ones who did mock trial. Because my 3rd daughter said from day one that, Dad, the one thing I know I don't want to be is an attorney. And so she is in pharmacy school and doing well. But my point is, you all would make great attorneys, but you're going to be great at whatever field you choose, because the way you approach things, the way you are prepared, how articulate you are, you're going to be successes. So I know your parents and family members are very proud. For the teachers and legal advisors, I know how much effort you put into this, and you certainly need to be recognized also. That's why I'm recognizing you, because these teams were obviously very well prepared. And that having been said, Danielle.
All rise. The Honorable Court is hereby adjourned. You may be seated.
Unless let's not forget the amazing job our timekeepers did.
Yes.
Time was all used. Very much.
Discrepancies between the two of you.
Well, congratulations, teams. And I just want to thank our esteemed panel of judges for taking the time to be here today. So a round of applause for our judges. Thank you so much. So we are going to get into awards, but judges, you are free to leave the bench. Thank you so much for your time here. We really appreciate you being with us today.
Well, the bottom line was it was our pleasure to listen to a well-prepared case that both teams presented. So thank you for the honor to listen.
You can wait to hear the awards if you would like, yes. I just did not, that's perfect.
Not kicking us out, are you?
No, not at all. We would never. So teams, we are going to present awards here. We have our awards table set up. So we'll announce awards. We will just ask that you wait for pictures until the end. We will also get some pictures, but we'll just have you come up when I call for award presentations. So I know this is really the moment you're all waiting for. Okay, so congratulations again to our teams, and I am going to start with the presentation of the James E. Phillips Outstanding Attorney Award and the Outstanding Witness Award. So congratulations to the winner of the James E. Phillips Outstanding Attorney Award, Gavin Addington. Here's your award. Congratulations. Congratulations to Gavin. And for the Outstanding Witness Award for this trial, congratulations to William Plavin Masters.
Thank you, ma'am.
Congratulations. Okay, drum roll. I can't do one, so I won't try. Thank you. All right, and now the moment you have all been waiting for. After 3 days and 5 trials, the winner of the 2023 Ohio Mock Trial State Championship is St. Edward High School. Congratulations. You may come up and get your award. Congratulations, everybody. Thank you. Congratulations. And we'll do pictures at the end. Congratulations. 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 If you guys want to take it back to your seat, we will pause for pictures. Congratulations, everybody. So, congratulations. And congratulations to the state runner-up, Talawanda High School. Please come and take your award. Thank you. Congratulations, everybody. Congratulations. Congratulations to everyone on a really long few days and a very hard-fought trial to get here. So we do want to recognize the individual students on the team. So we will start with, if I can have an advisor from St. Edward, if you wouldn't mind presenting gavels. We have gavels for all of the students on the team. We know only one side got to present today, but we do have gavels for all of the students. If you don't mind, you can just call their names and have them come up.
Okay. Thomas Lopez. Gavin Addington. Matt Doherty. William Plavin Masters. Cade Driscoll.
Daniel McNamara. Luke Stewart. Cody Wagner. Ethan Costco. And Seamus McGinney.
Thank you very much, and congratulations to the team and to the advisors that worked with the team. We know how much time you put into this. If we could have an advisor from Talawanda come forward and acknowledge the team members as well.
Elliot Berberick. Kate Bullenbaugh. Mohammed Khan. Shershan Moore. William Salzarillo. Eliza Sullivan. Thank you so much.
And thank you to the advisors as well. Well, it has been a long 3 days. Congratulations, teams. This was a special year as well. This was our 40th anniversary of the Ohio Center for Law-Related Education and of the mock trial program. So we were thrilled to have you all back in person for this year after a brief hiatus of being virtual. Thank you, everyone. Congratulations, and we hope to see you next year.
Congratulations to the winning team. You've been watching the 2023 Ohio Center for Law-Related Education High School Mock Trial State Championship. Today's winner will be heading to the National Championship in Little Rock, Arkansas. Please visit ohiochannel.org to view this program, along with past mock trial state championships. You can also see live and past video coverage of your Ohio government, including the Supreme Court of Ohio. Thank you for watching, and we'll see you next year.